Commission.
Are those principles mandated under the legislation?
I'm going to have to take that one on notice. I can't recall whether they were mandated or voluntary, but I will take that one on notice. Yeah.
Perhaps you could also take on notice, if they're mandated, how they're enforced.
And this is some of the area that is going to be picked up with the new draft legislation about being much clearer about some of the mandatory obligations under that, but certainly happy to take that on notice and come back to the Commission.
Thank you. Now, Ms Peake, as a result of the betrayal of trust inquiry, Victoria's developed some mandatory principles?
That's correct. So it is a principle-based legislative model that was gazetted in December of 2015 and has been implemented in 2 phases. So the 1st of January 2016, those standards were applied to government-funded and regulated organisations, and then from the 1st of January 2017, all other organisations, which means as at the 1st of January this year, they apply to about 40,000 organisations that provide services for children, including organisations, as I've said, that are regulated or funded by government, but also religious and not-for-profit organisations and sporting clubs. Importantly, that also includes organisations that deliver services to both children and adults. The standards are principle-based and they outline the type of policies and procedures organisations in those categories that have direct or regular contact with children need to have to ensure a child-safe environment. We did do a lot of consultation with South Australia and Queensland to ensure alignment with their legislative schemes, as well as an eye to that 2005 national framework. And then the most recent development is on the 1st of January this year, new laws came into effect, giving the Commission for Children and Young People the appropriate powers and functions to both raise awareness and build capacity about those standards, but most importantly to provide oversight and enforcement of compliance.
Were your standards set in stone by the time the Royal Commission published its 10 elements? They
were, but obviously in providing all of the explanatory material that the Commission has been preparing over the last 6 months, we've had an eye to the 10 elements that came through, or the elements that came through the work of the Commission.
What difference is there between the Royal Commission's elements and your standards?
They're largely analogous. I think there's a couple of differences. That we have a broad principle around empowerment of children, and I think the participation and decision-making principles in the Commission's elements are a bit more specific than ours, and that's where we've tried to pick that up a bit more in guidance. And I think there is a couple of other elements that were slightly more, again, slightly more specific in the Commission's work.
But broadly compatible?
Absolutely broadly compatible, correct.
Are your standards in a regulation or in legislation?
They're in legislation.
And you say they're mandated?
Correct, with the enforcement through the Children's Commission.
So what powers do the Children's Commission have in respect of them?
So in terms of determining whether an organisation has met the standards, the Children and Young People Commission has the power to request information from organisations as well as from regulators and funders. They can conduct inspections, which involves observing activities at the premises, inspecting documents and speaking with employees, children, volunteers and parents or carers. They must ensure that there's the appropriate notice period for doing that, and that there is consent to an inspection. If they form a view that there has been non-compliance, they can issue a formal notice to produce if they've got concerns. And then in terms of enforcement powers, they can issue notices to comply, which specify the action that the organisation is required to take to address a perceived failure to comply with the standards. If an organisation then fails to comply with that notice, the CCYP can can inform the funder or regulator of the organisation. They can request that that regulator or funder take any action available to it under law or under contract with the organisation to require compliance, and they can apply to court for a declaration of non-compliance and an order requiring the organisation to pay a fine. So obviously a graduated range of oversight and enforcement powers, with the real emphasis being on education and engagement and recourse to court as the last resort.
So I take it from what you've said that the Children's Commissioner or Guardian can take action of its own motion, and in fact there's no automatic way of information coming to its attention. It has to seek out.
So there is a regular process, which this is very new legislation, so it's in the process of developing how it will take a risk-based approach to going out and doing auditing, as well as getting reports through from funders and regulators. So we can provide you a bit more detail about their thinking in that regard.
So the intention is the information will come from funders and regulators rather than the organisations?
Unless there is a concern that's come to their attention, which might be through a complaint, it might be through their other mechanisms of relationships with children, young people and carers. It might be through any of their other inquiries that they do into the system, which may then trigger them to go into an organisation and seek to have documents produced.
Was there resistance in the sector to, firstly, the standards being legislated and secondly, being mandatory?
So we did really detailed consultation with the sector, really all sectors all the way through from really late 2014 right through until when the standards were finally legislated. And there was really overwhelmingly positive support for this. I think, as we've heard throughout the day, there was undoubtedly variability in people's readiness, and that was why there's been a bit of a lead-in and a phased implementation. But overwhelmingly, people saw this as an important addition and a way of really focusing they and their management teams and staff's focus on child-safe environments.
Thank you. Now, Ms Bennett, I think that the Australian Children's Commissioners and Guardians developed principles themselves following the Royal Commission's issues paper in this area. Now, are they some body that you have some role in?
If I just go back a step earlier, is that you referred to the 2005 COAG, Creating Safe Environments for Children. At the 11th of November 2016 meeting of Community Services Ministers, all jurisdictions agreed that these needed to be refreshed and updated, and that they...
I'll just stop you there and go back in time. Prior to that, it was the case, wasn't it, that the Children's Commissioners published some principles?
Yes.
Perhaps if we can just deal with that first, chronologically.
I don't have the principles that were with me for 2005.
Perhaps if I can ask any of the other members of the panel whether they were involved in or know of the work that the Australian Children's Commissioners and Guardians did post-August 2013 in relation to developing principles. Does anyone know anything about that?
Council,
No?
I need to be aware that it happened. I'm not familiar with the detail.
Did it have any effect on the work any of you did?
So, well, certainly we went back to that 2005 document as one of the inputs into our consultations, and the Children's Commissioner was involved in all of those consultations for us as well.
Council, I can add, in Queensland, the Premier tasked the Queensland Family and Child Commission in September last year to review the Working with Children regime, so including both the blue card component of that as well as the Chapter 8 risk management strategy component, and they've undertaken extensive consultation in relation to that, informed by the Royal Commission's Creating Child Safe Institutions standards, as well as I understand, the work that the Commissioners did nationally, and that's informing their work at the moment.
Thank you. Ms Bennett, you were taking us to November 2016.
At the meeting of the Community Services Minister, which is from all jurisdictions, including the Commonwealth, they agreed that the national statement, that there needed to be a new national statement for the principles of child-safe organisations, and that the 2005 child-safe framework was outdated, and that it needed to take into account that the work the Royal Commission was doing to, I can go through some of what we believe the principles will contain, but as part of that, the Commonwealth Government has commissioned the National Children's Commission, Megan Mitchell, to develop the National Statement of Principles for Child-Safe Organisations as a first stage of a practical, concrete tools for organisations to change the ways in which they work with children. We expect that the National Statement would cover organisational leadership and governance, human resource management, including employment screening, including working with children's checks, organisational policies and procedures to ensure child safety, children's participation and empowerment, complaints management and processes, cultural safety, online safety, family and community involvement and information sharing. So they're the broad areas that we believe reflects this, and the information that's been, or the guidance provided by the Royal Commission will also be taken up by Ms Mitchell. And I understand that she's had some discussions with the Commission, and she's about to commence some work on a series of jurisdictional workshops early in March, and has in fact had some meetings with stakeholders in service delivery and children agencies over the last 2 days.
Thank you, Ms Bennett. Now, at the time that Ms Mitchell was engaged to do that work, there was in publication the Royal Commission's 10 child-safe standards or elements, which you would know was the subject of extensive expert review and consultation. There was also the Victorian standards which had been developed. Why then was there a need to effectively start again at a Commonwealth level?
I wasn't suggesting that we were starting again. They were sort of the summary principles that captured the sources of information and also subsumed and other feedback. It wasn't starting again, and it's translating those into how it would be applied into an organisation. It's the tools that Ms Mitchell will be particularly looking at. So, you know, questions about what governance and culture mean actually need to be translated to how people will make those changes in their organisation that meet those elements that you've talked about, that I've briefly tried to summarise as well.
Sorry, I understood that what she was doing was providing a national statement of principles.
There's elements of this work. She's been commissioned to pull these aspects of what is the feedback from the jurisdictions and the information that your recommended approach, and to pull those into a set of principles, and then to look at the second component, which is how would it actually be practically applied and used by organisations.
I still don't quite understand her role when you say is pulling those into a set of principles. Yeah. There is a set of principles.
Look, I've got the information that's been provided from my office and the Commissioner. We can certainly go back and ask those questions.
Thank you.
I wouldn't want to leave you with the impression that this work, that the work that the Commission has done has not been significantly taken into account. And in fact, one of the big changes that across the jurisdictions is that the third action plan for the National Framework for Protecting Australians' Children actually has a dedicated strategy to the third of the three strategies to organisations responding better to children and young people to keep them safe. That was a quite deliberate recognition across the jurisdictions that previous national frameworks had often too many proposed activities, and they were diffused, and it was a recognition of the work that had been done by the Royal Commission to making that an absolute priority within the framework.
The Royal Commission is indeed, as we all know, a national Royal Commission. So one way of looking at these documents is that they are principles that have been drawn together by a national body and with consultation with national bodies. Has that been taken into account in engaging Ms Mitchell?
I'd have to ask her and look at what work she's been commissioned to do.
I referred earlier to the Australian Children's Commissioners and Guardians principles. That's tab 82 of one of the tender bundles. Perhaps it'll come up on the screen. It is on the screen. Now, this is a document that I'm told was produced or published in October 2013, and one will see from the front page that it's principles for child safety endorsed by the Australian Children's Commissioners and Guardians, each of whom is listed there. Perhaps if we can have the front page. And then you can scroll down, you see that? And then the principles are set out, there's 11 of them, and some detail is provided under each of them as to what one should do to put those principles into practice. Now, has any of the panel members seen that document before? Yes, from Ms Taylor? Anyone else has seen it before? Ms Peake?
Yes.
Victoria, South Australia?
I have seen it before, yes.
Mr Hogan?
Yep.
Western Australia?
Yes.
Tasmania?
I haven't seen it, but I wouldn't necessarily see it.
Mr Cootes-Trotter?
Yes.
So it's the case then, Ms Bennett, that in addition to what I've described, that is the Victorian standards, the Royal Commission's standards or principles, and now we have the Australian Children's Commissioners and Guardians principles in 2013, and yet there's still a need to put together another set of principles. It seems odd.
I can't comment on what the path to where we've got to on, but I certainly can provide a bit of mapping. And I just need to be really conscious that the Commonwealth Commissioner doesn't work for me, so I'll need to have a look how we've commissioned that work and tracked it through.
But you understand, when one looks at the chronology of it, there's been a lot of people, including two national bodies, this Royal Commission and the Australian Children's Commissioners, working on the very same project.
Yes?
And yet we need another project.
I think what I was trying to say is that our investment with the National Children's Commissioner is, yes, about the principles, but it's actually about her developing tools that allow organisations to move into meeting the expectations of those principles, what they have to do internally in a practical way to meet the arrangements, or what they have to do within their organisations.
As I understand it, the timeframe is that the principles will be developed over the next 18 months. Is that your understanding of the timetable?
It's a number of elements to that project.
I'm sure that is the case, but nevertheless, it's not anticipated that the principles will be available until the 18 months has expired.
I'll have to ask and see if I can come back to you on that quickly.
Mr Cootes-Trotter?
Councillor, the advice I have is that the statement of principles would be available in April of this year to the Children and Family Secretaries Group, and then from there, of course, for endorsement by the relevant ministers.
So that's the first stage of a draft being seen. Is it your understanding that it's unlikely that there will be agreed national principles for some time?
No, it's my understanding that there would be agreed national principles at an officials level in April, and that the further components of the work are to provide tools and guidelines to enable organisations in different sectors to adopt those principles in an appropriate fashion into their own organisations.
Can I say to both of you, or all of you, would be a very odd outcome if a Royal Commission tasked with looking at this issue, which was going to finally report in December, comes up with principles that are inconsistent with those developed by yet another Commonwealth body.
So-
Someone needs to rationalise the effort here and sort it out.
So my understanding from consultations I've been part of is that what ministers agreed to in November last year was to bring together all of this work, taking account of the final recommendations from the Commission, so that really goes to the question of timing of final endorsement by COAG, so that work is proceeding informed by the work that's already come through the Commission, and then from the end, it would take account of the final response at the end of the year, and then early next year there would be taking forward for a final sort of decision by First Ministers on a set of principles and other materials.
Thank you. You understand the point, though.
Yeah.
It would be a bizarre situation if we end up with
Correct.
different
Yep.
outcomes.
And I think, again, that timetable is designed to avoid that.
Do you understand, Ms Peake, that the principles that will ultimately be developed will be ones that are voluntary for organisations to adopt or otherwise?
I don't know that. The decision of ministers at the end of last year didn't go to that level of detail.
Thank you. Mr Cootes-Trotter, what work has New South Wales done in relation to developing child-safe standards?
So that work, of course, is led by the Children's Guardian in New South Wales. We have...
Sorry, when you say that work, what are you referring to?
The work of describing and promulgating principles for child-safe organisations is led by the Children's Guardian.
So is there work now that's being done that's led by the Children's Guardian, other than what we've discussed?
The advice I have is, yes, there is. So the Children's Guardian, of course, already regulates a set of child-safe standards for permanent care and accredits organisations to operate as care providers under those standards.
But they're out of home care standards.
They're out of home care standards. But I'm told that the Office of the Children's Guardian has prepared draft guidelines to assist child-related organisations to implement child-safe principles, so organisations beyond the care sector that do consider and condense the 10 elements outlined by the Commission in your work, and that those principles and draft guidelines, not yet released, but would be available for consultation from April onwards.
So these standards or guidelines are following on and different from the 2013 guidelines I just took you to in tab 82?
I don't know because I haven't seen the guidelines that are yet to be released for consultation.
But if they're yet to be released, it must follow that they're relatively new in that
Yes.
case.
Yes.
So you wouldn't anticipate them to be the same, although perhaps built upon the 2013 guidelines?
I shouldn't speculate on that.
Perhaps you can find out and tell us.
Yes, of course.
The relationship between what you've described and what
And
happened.
the Children's Commissioner's guidelines from 2013.
Yes,
Yes.
thank you.
Or principles from 2013.
So I take it then that what you as a department and perhaps a government is doing is working with the national framework
Yes.
and the work that Megan Mitchell is doing, and those standards will become yours.
Yes.
You're not doing anything independent.
The FACS is doing nothing independently, no.
Now, Mr Hogan, I take it you're in the same position?
We are in a similar position. There is another element, relationship between the risk management strategy requirements under the Working with Children legislation and our Human Services Quality Framework, which we apply to all funded organisations by my department in Queensland, which directly link to the Chapter 8 component of the Working with Children check legislation. So if that means they're subjected to a 3-yearly audit cycle in relation to their compliance with a range of human service standards, and the material that goes to their satisfaction of that in relation to the safety of their clients links to the Working with Children legislation.
Thank you. Ms Kerr, is it the case in Northern Territory that you don't have anything in place at the moment and will be awaiting the outcome of the work that's been described?
Yes, and also the Royal Commission in the Northern Territory.
certainly. Mr Dath, is that the same in ACT?
We have adopted the national standards for out-of-home care. We will review our policy platform around this whole area in 2018 as part of a planned review, where we intend to be incorporating all national work and Royal Commission findings. We have established the Human Services Registrar to oversight all of this work, and the suitable entity criteria that the Human Services Registrar uses aligns with the Commissioner's principles that you referred to earlier.
Are you part of this national framework or project that has resulted in Ms Mitchell being engaged?
I'm sorry, I can't answer that. I'd have to take that on notice.
Well, I take it that the national framework is something that you're part of. Is that right?
Through the CAF's work, I believe we would be engaged with the work.
Are you aware that this work has been going on since November 16?
Not fully as described, but I'm relatively new to that group, having only been in this role for the last 6 months.
Ms Taylor?
So I'm aware of the commitments that were made last November by the ministers. Obviously, as my colleague from Victoria has flagged, it really is intended that we get strong alignment with the Royal Commission standards and principles, but we also need to ensure that from, for example, a South Australian perspective, we don't want to see a dilution of what we've already got in place. So that's always one of the challenges. We don't want to find the lowest common denominator, but we also want national consistency.
But as with the discussion the other day about working with children checks, there could be a national minimum standard and those that wish to go above it could.
Absolutely.
Sounds sensible, doesn't it?
It does.
Because it avoids discussions like, you know, you're stronger and I'm weaker or vice versa, doesn't it?
It does. Look, certainly for us, we have long been committed in South Australia to child-safe environments. It's been reflected in legislation. We've taken the opportunity with the new legislation to update it. We're a strong contributor, along with Victoria and Queensland, to the work that's been done over the years. We don't want to see that lost. We really are keen to see national agreement and national commitment moving forward.
Thank you. Is Tasmania in the same position as the territories?
No, we're not. There's two streams of work that are happening in Tasmania. The Department of Education has developed a Child Safe Policy and Procedures project in consideration of the work of the Royal Commission. The purpose of this project is to facilitate the ongoing development and review of the department's approach to providing a child-safe environment. The department's ongoing work includes, under the current National Safe Schools framework and a Respectful Schools and Workplaces framework, which has been developed in Tasmania, mainly in response to family violence and associated issues for young people in that context. And the work that's being done to develop child-safe schools is happening consistent with that other work. So the objectives is to ensure that compliance with child-safe organisation principles is strengthened, and that there's clear policies and procedures in place, and the framework that has been set out by the Royal Commission is very much driving and informing that work. The second stream of work is in the Department of Health and Human Services. There has been a major review of the child protection system in Tasmania, which reported, I think, 12 to 18 months ago, and there's a whole system redesign project going on there. And again, the principles that have been set out in the Commission's report are being used to inform that work.
I might take it from that that Tasmania doesn't have any standards in place at this time.
Well, we do have principles set out in the current Children, Young Person and Their Families Act, 1997. And then that Act actually requires people with responsibility for the care of young people to behave consistently with those standards. And there are enforcement mechanisms under that legislation, both for failing to report, but also failing to properly provide for for children and young people. No doubt that will need to be reviewed in due course, but there are standards in place. The other thing that's happened is that the Children's Commissioner in Tasmania has developed a Charter of Rights for Tasmanian children and young people in out-of-home care. This charter has been distributed to children under the care of the state to raise their awareness and empower some of the most vulnerable children to have their voices heard. The charter also requires child protection workers to maintain a relationship and have regular meetings with children they work with to ensure their ongoing safety, development, suitability of their placements, access to support and the opportunity to raise concerns through regular meetings with their workers. These meetings are monitored. They're one of the key performance indicators for the department.
Just leaving aside out-of-home care for the moment, the principles you described in the Children, Young Person and Their Families Act 1997, have they been amended since the Act was enacted, do you know?
I can't answer that. I'd have to take that on notice.
Ms White, what's happening in
Western Australia?
Australia?
We're certainly aware and will participate in some of the national standards work that's been already outlined, including the staged approach to bring this effort together early in the new year. With regards to Western Australia, the Commissioner for Children and Young People published a set of child safety standards in April of last year, very much based on and in line with the work of the Commission. In addition to those standards, they developed with a range of agencies involved, including Child Protection, some different tools and resources that organisations can use to make sense of the standards and understand their practical application. They also included an organisational self-assessment matrix that organisations can work through. Excuse me. In terms of out-of-home care, we've been, as part of our out-of-home care reform agenda, reviewing our Better Care, Better Services, which is a set of standards that was developed with the community services sector back in 2006. That's under active review. In fact, we're almost at the point of approval, which have incorporated in a more granular, detailed sense the standards that have come through the Commission and aligned to the West Australian standards. In May this year, we go to full procurement of all our out-of-home care services, and the new contractual arrangements will, the revised Better Care, Better Services standards that incorporate the child safety standards will be key components of those contractual arrangements. That's probably the main things.
Thank you. You and I have nothing further.
Does anyone else have any questions?
Just one point of clarification, if I may. Thank you, Commissioners. And Ms Bennett, correct me if I'm wrong, it appeared there was some confusion about whether the National Statement of Principles will be a fresh start or will draw on the work that's already been undertaken. And Ms Bennett, is it correct that the National Statement of Principles will not only draw on the research work that the Commission has undertaken and existing state and territory standards and reforms, but will also include the pre-existing national guidelines and work since the release of the Commission's reports?
Yes, you're correct. I can refer you to the Community Service Minister's communique on the 11th of November, which explicitly stated that the National Statement of Principles for Child Safety Organisations will draw on the recommendations of the Royal Commission into institutional responses to sexual abuse, which was released on the 18th of August.
That's not quite the point.
No, but we can provide you, if it's of assistance, with some information around the tools that Ms Bennett referred to, or the work plan, the project plan that's been developed.
Well, I think we need that, because I think we need to understand that it's all very well to set up inquiries and restate principles over and over again, but one has to come to a common position, which this Royal Commission was charged with doing in the first place, and then take it forward into practical outcomes. So the point is not unimportant. And we'd appreciate assistance in resolving it.
We'll provide you with some material.
If I could just add slightly, is that I think the point being made is that the Royal Commission research study in which you provide the principles was released on the 18th of August, and ministers took that into account at their meeting on the 11th of November. And as you've heard today, that there are existing state and territory government arrangements on safe standards and reforms, and there are a lot of work that's occurring in individual jurisdictions. And so that the context for this is that taking into account the research study pending the final report expected from the Royal Commission, that this collaborative work that's being done across jurisdictions will look at those recommendations and direction that's set out under the research study, and work that's been done nationally, and the past elements, and what we've got on international conventions, which is referenced. And that will turn into a set of deliverables which we're hoping to get jurisdiction agreement or COAG agreement on, which is the National Standard of Principles. And as I read them out, I think I was talking in shorthand, and I would believe that you would find embedded all of your points made in that. And that principle, that overarching principle, and in consultation, that basically that will come out of that work, which Mr Coates-Trotter referenced. The principles would come to the CAFS meeting in April, and then that would be relayed to community service ministers in mid-2017. And then if there is endorsement before it is finalised and before your final report comes out, that work will be done on a project plan which looks at activities and costings of implementing and the subsequent stages, including memberships of an advisory group that will guide the development of the principles through a national cross-sector engagement process, and work out what tools and resources will be needed across all the sectors and different organisations to translate these, what will be endorsed and nationally agreed, into the way that changes the culture and the operation of organisations.
I think your point is well understood, and as I indicated earlier, I think your point is absolutely well understood, and the intent and really Special Counsel's question about the mid-2018 timeframe for the final endorsement by COAG, First Ministers itself, is absolutely with a view to keep starting the engagement with the sector, but adapting anything we need to adapt past the final report of the...
Given me some feeling of comfort.
That was certainly the intention, Your Honour. But if further details are required, we can certainly liaise.
I think there'll be some more discussions. Yeah.
Your Honour, please.
Anyone else have a question?
Your Honour, I have nothing further for this panel, but I haven't to tender a few documents and do various things.
But they can all go, can they?
They can indeed all go.
And then you're all excused with our thanks for the contribution you've made, some of you over an extended period of time, over many important issues. Thank you.
Your Honour, while they're leaving, I need to tender a few extra documents. The first is a document from the Department of Immigration and Border Protection concerning the breakdown of complaints reviewed by the Child Protection Panel.
It'll be Exhibit 51.5.
A letter dated the 6th of March 2017 with Commonwealth updates and attachments concerning a Working with Children check and a draft guideline in relation to, I think, model litigant matters.
That'll be 51.6.
Thirdly, a Queensland Government document titled Questions on Notice, which essentially relates to the Working with Children check matters that were discussed.
It'll be 51.7.
And finally, an email dated the 8th of March from a representative from Western Australia in relation to coverage of non-government organisations in their redress.
Sorry, what is it again?
It's an email dated the 8th of March 2017 responding... Where is it?
This is dealing with an issue raised yesterday, isn't it?
Yes. No, this is different.
I see, yes. That'll become 51.8.
Thank you, Your Honour. And at the commencement of the hearing, Your Honour, I indicated those who were assisting the Royal Commission. That was in relation to the first panel. There are additional people who I might just announce now. Ms Kalopoulitis, Ms Payne, Ms Carter, Ms Jayamani and Mr Stevenson.
Very well.
Now, Your Honour, that's the completion of case study number 51 and case study 52 concerning the Jehovah's Witnesses and the Uniting Church will commence at 10 a.m. on Friday.
Very well. We will adjourn until then.
Thank you, Your Honour.
All stand.